Welcome to Aging Insight with your host, John Ross and Lisa Schollmeyer. This program is made possible by
Welcome to Aging Insight. I'm Lisa Schollmeyer and I'm here with John Ross, and we are elder law attorneys based here in the Arklatex area. And Aging Insight is a program that you can catch every week, which we hope brings some information and answers to your questions that you may have as it comes to questions about as you retire, dealing with estate planning, dealing with children, grandchildren, medical needs, financial needs, benefit programs. There's a minefield of issues out there as you get older, and Aging Insight is here to help you address those.
Yeah, we try to bring in all the different little pieces of knowledge that relate to taking care of yourself while you're alive, trying to preserve your personal dignity while you're alive and preserve that legacy after you go. And there's just lots of little pieces to that puzzle. One in particular, and Lisa, this kind of comes from a favorite quote of mine from a novel, that all happy families are happy in the same way, but unhappy families are each unhappy in their own unique way.
Yes, and extra bonus points if you can name the novel.
But everybody's family is a little bit different, and when you start making the decisions as far as who you're going to leave things to at death, it's not always Brady Bunch.
Well, and I would say it's not always, June and Ward Cleaver from Leave It to Beaver.
That's right.
So I'm sure our viewers are probably a TV generation and know what we're talking about there. But we have all kinds of different families these days, and when it comes to planning for your family after you're gone, there's a lot of misunderstandings and misinformation out there. And so today we want to talk about what choices and what rights you have when it comes to planning for your family in the future for after you're gone.
Yeah, and this is particularly important when you start talking about making a disproportionate distribution among your family. So maybe, for example, you have 4 kids, but for whatever reason you want to leave your estate instead of just equal fourths, you want to benefit one more or maybe one less for whatever reason. Your reasons are ultimately your own. But you get to leave things however you want to. So the first thing to understand in all of this is that you can leave your assets to absolutely anybody you want to, or omit anybody you want to. So there's no actual requirement that you leave anybody anything. Lisa, there's that common misconception that if I don't want to include this person, I need to leave them $1.
Right. I hear that all the time, and we see that all the time in documents. And the reality is that you can make whatever choices you want. Most of my clients and folks I talk to, they say, hey, I like the idea of, taking my last breath and bouncing my first check all about the same time. So first and foremost, use your assets and what you've accumulated to enhance your quality of life through your retirement years. Take that vacation, make that charitable gift, and support that organization that you are led by your heart to do so. Don't worry about family and what their expectations are. You use your funds for you. Now, leaving a legacy is a big part of what people want to do with their assets, but as John and I were just discussing, you get to decide that. And if you choose to omit a family member from receipt of any of your assets at death, you are free to do so, but you want to do it the correct way. There might already be a broken relationship or hurt feelings with that family member we don't want to incorrectly omit them from your estate planning and create more drama for your actual selected heirs and beneficiaries. So, John, that common misconception where if you want to omit someone or write them out of your will where you're supposed to leave them $1.
Yeah, that's not only is it not required that you leave somebody $1 or $5 or whatever it is, but if you're trying to omit that person, leaving them anything at all, even $1, is a bad idea. Because what you have done is not just left them $1, but you've given them rights. You've entitled them to notice of the probate proceedings, the ability to participate and then question the administration of your estate. They get to know what you had at your death. They get to know the types of assets, the nature, the value, who those things are going to, and in what shares. So by just giving them $1, you have not only, in attempting to leave them out, what you've actually done is brought them in, which was the exact opposite of what you were trying to do.
Well, okay, John, let's say that, I had a professional that told me to do that and drafted my document that way. Then I passed away, and that child that I left $1 to is just giving my other children, whom I left the rest of my estate to, if the child left out is giving them trouble, why can't the executor or one of the other kids just reach in their pocket and pull out $1 and say, look, here's your $1, just go away.
Now go away. But it's just not that simple. The laws don't provide that. Every beneficiary has certain rights as far as the process of the administration. And by making them a beneficiary, even for such a small amount, you've included them in that process. Now, that doesn't necessarily mean you just omit them completely.
Right. So, John, it looks like it's about time to take a break. So we'll come back to, in the next segment, we'll talk about the correct way to limit or omit a beneficiary from your estate planning.
The Wadley Senior Clinic has been such a blessing for our family. Because they specialize in geriatric care, they take the time to really focus on Dad's needs. Their exam rooms are specially designed for seniors, and they offer lab and x-ray on site. With monthly educational programs on health and wellness of the mind and body, our healthcare questions get answered. Best of all, they accept Dad's Medicare benefits. See what the Wadley Senior Clinic can do for you. Wadley Senior Clinic, where healthy relationships begin.
Hi there, I'm Larry Sims. It's been my privilege for the past several years to be a volunteer board member of Hospice of Texarkana, and there I'm able to represent community members like you. We continually customize our end-of-life care to better meet the needs of our community. As an example, our medical director and nurse practitioner still make visits to homes and facilities. Call today to learn more about the help we can give your family. Hospice of Texarkana, the nonprofit hospice established in 1985 for the community, by the community.
Welcome back to Aging Insight, everybody. I'm your host, John Ross, here with Lisa Schulmeyer, and today we're talking about how to make disproportionate distributions among your heirs. So, you've got people that you're planning on leaving stuff to, but maybe you're going to leave that unequally among them. Maybe you're going to omit somebody or some group of people entirely. And there's lots of reasons behind this. Sometimes people have had a falling out with that person. Maybe they feel like they have benefited that child
greatly during their lifetime.
It
happens.
And not the others, and so they want to benefit the others at death.
Sure.
Maybe they've just never had a relationship because of a divorce or some other proceeding.
And sometimes even I've had folks feel like, well, there's certain members of my family that have had a harder time, worse luck, and they really need the asset, while you maybe have a great relationship with all of your heirs, but maybe not all of them need anything.
Right. In my own family, there's been family members where, two brothers, and one of them is very, very successful, and one of them has just had one string of bad luck after another. And so, yeah, so there's lots of different reasons. But right before the break, we were talking about that if you're going to omit somebody completely, the one thing you don't do is leave them $1. That is one of the most pervasive myths that is out there.
And I see it in documents every week. So if you already have a will prepared and that was an important issue to you to make sure that you disinherited an heir, then I would
get that thing looked at.
That's right. Pull it out and look at it. And if it says you're leaving that person $1, then you need to call an attorney and get that fixed.
That's right. But that doesn't necessarily end the discussion, because if you're going to omit somebody, there's also another little law out there called the Pretermitted Child Statute. And that's just basically a big fancy word for saying that you messed up and forgot somebody. So let me give you the scenario. Let's say that I had 2 children, and when I have these 2 children, I make out a will and I say I leave everything to my 2 kids. And then a year later, I have a 3rd child. But I never get back around to amending that will and then subsequently die. So I die having 3 children, but my will says I only leave my assets to these 2. Well, the law then presumes that I made a mistake, that had I thought about it, had I had the opportunity, I would have gone back and included that 3rd child. So my omission of that child from the will, that child actually gets to step back in and take a share as they would had I died without a will at all. So if it's not a mistake on my part and I'm just not including that one particular child, this needs to be extremely clear in the document. I need to say, for example, I have 3 children. However, this one child I am providing no benefits for under this will, and I want them to be treated as having predeceased me. That means that they're no longer a beneficiary. You've specifically mentioned them, and yet also disinherited them completely in the same document, in the same paragraph. And that's a big difference there. Lisa, we were talking about when you give somebody $1, they've got all these rights and everything. Mm-hmm. If somebody is completely omitted, they actually lack something called standing.
Right. So, if they're completely omitted, then they have no standing, which means they have no say about the proceedings that take place when a will is probated. We were talking about at the first segment that if you leave somebody $1, they're entitled to get a copy of the inventory of your estate. They're entitled to know the nature and the amount of your estate. They're entitled to complain about how the estate is being administered. Well, if you omit them properly by identifying the child or heir that you are specifically not leaving any property for, then that person lacks the legal standing to complain about any of those things.
That's right. Now, that's if you're going to leave them out completely. But I would say that more often I will see people making a disproportionate distribution. So they're not omitting somebody, but for whatever reason they're leaving things in different shares.
Yeah, so it's not equal shares, but maybe they're doing percentages, 60% to this child, 40% to this child.
Right. And again, whatever their reasons are, those reasons are their own. But now, anytime so just again, for example, let's say that I do up a will, and this will says that I've got 2 kids and I leave 60% to one and 40% to the other. If the will is valid, then everything goes as I want. But if the will were to be determined invalid for some reason, like for example, if I didn't have the mental capacity to execute the will, or if somebody unduly influenced me into making that will. If for whatever reason the will is determined invalid, then I would be treated as having died without a will. And if I die without a will, then presumably my property would get split 50-50 between these 2. And this is the recipe for a battle.
Right, because in that situation, if a child through a will is left a less than equal percentage, then that child has every motivation in the world to try to have that will declared to be invalid.
That's right.
So
and that way they
that
get
their
other
proportion
piece.
is restored as equal to the others. So it's, you know, it's really kind of a motivator, or it could be depending on circumstances, because what do they have to lose?
Right. And that's the key there, is the what do they have to lose? So this brings in something called an inter rerum clause, which is just fancy Latin. In most cases, we talk about it as a no contest clause. So this is a specific provision in the will or trust or whatever estate planning document you're using that says, you know, here's how I've set this out, and this is the way I want it. And that if somebody contests this will, if they make a claim that I was unduly influenced, if they make a claim that I lacked mental capacity, if they make those claims and lose, then they are treated as having predeceased me.
So in effect, what happens is if you have a beneficiary who is granted a lesser percent of your estate, and so they just get their hackles up and they go to the courthouse and they contest your will. If the ultimate outcome is the child loses that contest, so that the court agrees with you that you were competent when you made the will, that it was all done properly, and the will is valid. If the court agrees with that, then with a no contest clause, the child who challenged, now they have forfeit any benefit they receive under the will. So they could have been in line for that 40% if they had accepted that 40% as written in the will, but if they get upset about that and they go contest the will, then if they lose, then they forfeit their 40% and they're left with a big 0%.
Yeah, which that can be the idea is, you know, I often describe it in client meetings. I say we're trying to take the dog out of the fight. You know, before they ever fight, we want to give them something to lose. And the idea is you want there to be consequences. If there's no consequence, then that person who's getting the 40%, as Lisa said, has nothing to lose. If they go for it and lose, they get their 40%.
They still get their 40%.
If they go for it and win, they get 50%. So there's nothing stopping them from trying. Alternatively, though, if you include this sort of inter rerum or no contest clause, then you've given that, you know, well, geez, if I lose, then I lose it all.
Yeah, I better
so
think about this.
I better just take my 40% and be happy with it and go on down the road. And so that can be a powerful motivator in all of that. Now, all of this has been talking about primarily about putting these things in wills and stuff. And that's where you see a lot of these. But that, if you're leaving disproportionate distributions, the will may actually be one of the worst options in all of this. But we're going to talk about that after we take our next break. So if you want to find out about that, you're going to have to stick around for just a second. We'll be right back.
Hi there, I'm Larry Sims. It's been my privilege for the past several years to be a volunteer board member of Hospice of Texarkana. And there I'm able to represent community members like you. We continually customize our end-of-life care to better meet the needs of our community. As an example, our medical director and nurse practitioner still make visits to homes and facilities. Call today to learn more about the help we can give your family. Hospice of Texarkana, the nonprofit hospice established in 1985 for the community, by the community.
I'm so glad we found the Wadley Senior Clinic. Their team specializes in caring for older adults, and their doctors listen and work with me to keep me healthy and independent. With monthly educational programs, x-ray and lab, and state-of-the-art exam rooms, I get expert care and understanding about what I'm going through. Best yet, they're easy to get to right off the interstate at Jefferson. See what Wadley Senior Clinic could do for you. Wadley Senior Clinic, where healthy relationships begin.
Welcome back, everyone, to Aging Insight. I'm Lisa Scholmeyer here with John Ross, and today we're talking about the idea of maybe dispersing your estate in disproportionate shares between your natural heirs. So if you have 3 children, instead of leaving everything in equal shares where each child receives 33%, you're picking and choosing, and you're saying, for whatever reason, I want this child to have 60%, and this child can have 20%, and this other child can have 20%. So if you're doing something besides equal shares, which you are perfectly entitled to do under the law, you want to pay some special attention to making sure that you've got this nailed down properly to avoid a fight or any more damage in the family relationships after you're gone. And so, John, in the first 2 segments, we were really talking about that more from the standpoint of using a will.
That's right.
A last will as the primary tool for passing that estate to those children in whatever proportion. Mm-hmm. But yet that's not the only way to do it.
No, and this is where you can actually, you can start running into both problems or opportunities to avoid those problems. Because, the first thing in all of this is that every will must go through probate in order to be valid. So in Texas, you have to probate the will within 4 years after death. In Arkansas, you have to probate the will within 5 years after death. But in any case, for a will to be valid, it absolutely must be probated. There's no question about that. So when you start talking about leaving a disproportionate distribution, anytime you walk into the courthouse, you're inviting somebody else to walk into that courthouse and create a battle. Create a fight, challenge something that you have put down, or challenge the authority of the people that you thought were in charge, or whatever the deal is. So a lot of times, the better alternative is to look at ways to pass your assets outside of probate. So for example, Lisa, let's say that I had 2 kids, and I had loaned one of the kids a bunch of money over time, and so I want to give the other kid some more money when I die, right?
Very
now,
common.
I could still have a will that says I leave everything to the 2 of them in equal shares. But then, let's say I've got a CD over at the bank, and maybe that CD is about the amount of money that I want to leave to this one kid as a little bonus, a little extra. Instead of including that in the will, I might just put a beneficiary designation.
Right. So in that case, the CD says that while you're alive, you own it and you can do whatever you want with that CD. But at your death, the CD has a beneficiary designated of that one child that you want to provide a bit more cash to. And so in that situation, that child just presents themselves to the bank, and the bank disperses the funds to that child, and there's no opportunity for a fight.
Yeah, passing something like that is very simple, very easy, and very quick. Mm-hmm. And so from the time you pass away until the time that child can walk into that bank and claim that CD and walk out with the money, it's very, very fast. And so also you have this will that leaves everything equally, and nobody's going to challenge a will that leaves everything equally. Right. Because why? So you've taken away the reason to fight about the will, and yet you've still disproportionately benefited that one child, but you've done it in a way that's much more difficult to contest because it's not part of that probate proceeding. The other way, if you want to do this with your entire estate, for example, is to use something like a trust as your estate planning vehicle instead of a will. Assets that are in a trust also pass outside of probate.
Right. So you don't have that. You don't have to go to the courthouse. So there's never that opportunity for the fight to develop at the courthouse over a probate matter, because if you use a trust as your primary vehicle for your estate planning purposes, it's a private document. It is not required to be approved or submitted to the courts, and it's much more. A trust is just much more difficult to challenge.
Yeah, in fact, it's not available to our Texas viewers, but for our Arkansas viewers, if you have created a trust and you give a copy of that trust to your, let's say your kids are the beneficiaries when you die, if you give them a copy of that trust while you're still alive, then they are barred by law from contesting the validity of that trust later on when you do die.
Well, and you can use that to your advantage because most, a lot of times in these situations, most kids don't want to cause any trouble or upset mom or dad, while they're living, but yet they have no problem fighting with their brothers and sisters. So in a situation like that, give a copy of the trust to the kids. They may be plotting that they're going to do something after you're gone, but in Arkansas, that doesn't happen.
That's right. So, and frankly, just the communication sometimes, if you are benefiting one child more than the other child for some stated reason, sometimes having that conversation can just be the one thing that keeps them from fighting. They don't feel like their feelings still may be hurt a little bit, but at least they understand why. And if they understand that early on, then by the time it gets to the actual distribution, maybe they've come to accept it. Oftentimes, more than anything legal, just good communication among the family members is probably one of the best ways to avoid fights.
Sure. So, so I hope you've learned something today in our discussion of, leaving your estate in disproportionate or unequal shares. We want to remind you again that your property is your property and you can do whatever you want to with it, or you can do nothing with it. It's yours. But if you do want to make plans with your property, make good plans that will accomplish what your goals are.
That's right. And of course, if you have more questions, you can always reach out to us every Saturday at noon on 98.7 FM. That's our Aging Insight radio show, or you can pick up a copy of our Aging Insight magazine, which has got some good articles on there. Otherwise, you can stick around until next week and catch another episode of Aging Insight. We'll see you then.
Bye-bye.
Thank you for joining us for this week's Aging Insight program with John Ross and Lisa Schollmeyer. This program is made possible by